Tēnā koe, Mr. Speaker. Rero na kia ora tātou katoa e te whare. Mr. Speaker, this bill to remove the right of anyone in jail to vote is a direct attack on the democratic freedoms of people we should be trying to help, an assault on the intelligence of ordinary New Zealanders, and another in a raft of misbegotten, panicked pieces of legislation that is driving this country over the precipice into the mindless depths of right-wing insanity. Even the Law Society, Mr. Speaker, didn't like it, for heaven's sake, basing their opposition to the bill on its contravention of the 1990 Bill of Rights Act and Article 25 of the United Nations International Covenant on Civil and Political Rights. The Law Society called it retrograde legislation, which would erode the free and democratic nature of New Zealand society without justification. They called it irrational, they called it arbitrary, they said it was unreasonably impairing the right to vote, and they said it was out of due proportion to the objective of punishment and out of line with international law. The Human Rights Commission said the bill would impact disproportionately on Māori and may therefore amount to indirect discrimination which could not be defended as reasonable. They also said that this bill was inconsistent with the aim of the penal system to rehabilitate offenders. Those basic human rights come from a long history, starting back with the 1852 New Zealand Constitution Act, which actually disenfranchised prisoners back then for, and I quote here, any treason, felony or infamous offence within any part of Her Majesty's dominions. That history also includes a declaration from the 1975 Electoral Act Committee which said there was no justification for taking away an elector's political rights if detained in a penal institution. 3 years later, in 1978, New Zealand ratified the International Covenant on Civil and Political Rights. That was followed by a statement from the Centre for Human Rights which said excessive limitations on the voting rights of convicted criminals are not permissible. In 1992, the Solicitor General said that removing voting rights for more prisoners was a breach of the Bill of Rights and that imposing limits on that right was unjustified. And now, in 2010, we find that our current Attorney General, the Honourable Chris Finlayson himself, has attached a note to this Electoral Disqualification of Convicted Prisoners Amendment Bill, alerting Parliament to his view that this bill will strip individuals of a fundamental right in a way that cannot be justified in a free and democratic society. A colleague of Mr. Paul Quinn himself. Mr. Speaker, everyone knows that Māori make up 50% of an already overstretched prison population, a gross overrepresentation in sentencing, incarceration and recidivism rates that is a damning indictment on our society and our justice system in particular, and this bill will make it even worse by further isolating and segregating prisoners from society and adding another punishment to the one already handed down by the judge. One of the submissions received by the Select Committee was from a woman who reported on a recent ruling in the United States Court of Appeal which said that the removal of a prisoner's rights to vote was a breach of the Voting Rights Act and that it discriminated disproportionately against those ethnic minorities who are overrepresented in the prison population. She also said that this proposed bill would contravene the Bill of Rights in respect of both the right to vote and freedom from discrimination. And just picking up on a comment from the Labour side of the House, I think this might be that same example. This woman provided a local example where two young men were convicted of the same offence. One from Fendalton, or depending on where you live, Fendalton, and the other one from Aranui. To no one's great surprise, the one from Fendalton got home detention and the one from Aranui, convicted on the same offence, got sent to jail. By way of context, this bill says that people who get home detention can vote and those who get jail can't. Fendalton, of course, is one of the wealthiest suburbs in Christchurch, with a Polynesian population of just 3%. And Aranui is one of Christchurch's not-so-wealthy suburbs, with a Polynesian population of 40%. So there you go. When they get convicted of the same offence, poor brown people go to jail, and rich white folks don't. And now, thanks to this bill, poor brown criminals will lose their right to vote, while rich white criminals won't. Finally, Mr. Speaker, I draw on a Ministry of Justice review last year which confirmed bias against ethnic minority and Indigenous peoples at every stage of the criminal justice system, from stop and search to arrest, charging, prosecution, mode of trial, conviction, pre-sentence reports, sentencing, incarceration and parole. That review also found that over 40 years of international research had failed to provide a successful blueprint for addressing ethnic disparities, and that a comprehensive policy approach was needed to address the direct and underlying causes of ethnic minority and Indigenous offending. Mr. Speaker, this bill will achieve absolutely none of that. Every intelligent commentator, every human rights ruling, every valid piece of research and every anecdotal piece of information we have to hand, both local and international, tells me that this bill is not only bad legislation, it is dumb legislation. It will disenfranchise Māori voters. It will do nothing whatsoever to protect the citizenry of this nation, and the Māori Party will be opposing it at every single stage. Kia ora tātou.